Welcome back, folks. We're turning now to Iowa, where a woman is facing up to 50 years in prison for starving her baby and leaving them to die in a ditch.
Back in July, Rodney Staude pled guilty to second-degree murder and the death of her newborn baby. Investigators say that Staude placed the baby in a box in her home and ignored his cries off and on for 2 days.
She then allegedly placed the baby in a plastic bag while he was still alive and left him on the side of a snowy road with the help of her father. Now, in a surprise move today before Megan's sentencing, her father also took a plea deal. I'm going to get you into court now as Rodney Staude is addressing the court.
And did you commit that offense?
Yeah.
Mr. Stouty, now I need you to tell me in your own words what you did to be guilty.
Like the story of what happened. Well, I just came home from work, and she seemed to be fine on a Sunday. And then Monday morning she said, "Dad, I don't feel good." And I said, "What's wrong?" She said, "I just don't feel good. I'm gonna call my boss and go to work, not to go to work today." So she did. And she said, told her boss that she spotted some blood. And when she spotted blood, I thought, well, maybe she's doing something that she shouldn't be doing at work, like lifting crates or having heavy equipment, stuff around for a housekeeper does. And she spotted blood again. And she says, "I think I overdid myself." And she said that the co-workers asked me if I was pregnant, and I told them no. So she just, I just didn't pay attention to her at all. And then she decided to go back to work on Tuesday, and the co-workers asked her if she had a baby, and she said no. And she went on to work, and that's about all I can tell you.
Mr. Stouty, can I ask you, when you say she, are you talking about Megan?
Yep.
Your daughter?
Correct.
Okay. So,
What did you do?
Okay, and then not only that, I had a job to do. I worked nights, and she worked during the days, and I couldn't take care of it during the day because I sleep the most of the day, get ready for work, and she worked during the night, days to daytime to work.
okay. So when you say you couldn't take care of it,
That's right.
Megan had a baby,
Correct.
and it was alive when Megan...
And baby was alive when I got home that night.
Okay. And you stated you couldn't take care of it.
I couldn't take care of it, that's correct.
Okay. You said Megan couldn't take care of it. Is that correct?
Correct.
So what did you do?
So I end up, we talked some more, and then finally I said, "We can't take care of this baby, Megan. It's going to cost me too much money to take care of it." And she decided, "Well, I don't know what I'm going to do. I'm scared." I said, "Well, first thing we're going to do is see if we can get a bag." We found a bag and put the baby in the bag and drove out in the country and dumped it in the ditch.
Okay. And when you dumped the baby in the ditch, in the bag, was the baby still alive at that time?
Yes.
Okay. And when you put the baby in the ditch, what did you and Megan do?
Just took it, we drove off.
And you left the baby there?
Right.
And when you left the baby there, what did you think would happen to the baby?
It would die.
And all of this that we've been talking about, I know this is a while ago, but would you have any reason to disagree that this was somewhere in February of 2023?
Correct.
Okay. And did all these events that you just talked about take place here in Warren County?
Correct.
Mr. Eichholz, are you satisfied with the guilty plea?
Yes, Your Honor.
Mr. Owens?
Yes, Your Honor.
As far as it pertains to proposed testimony that would support a conviction of murder in the second degree, does either counsel have any objection relying on the minutes as testimony to support the plea as long as the court excludes anything that may implicate murder in the first degree.
We have no objection, Your Honor.
Mr. Eichholz?
No objection, Your Honor.
All right. Mr. Stouty, then I will ask you one last time. Do you still wish to plead guilty?
Correct. Yes.
Does either party know of any reason why the plea should not be accepted, or is there anything which the court has omitted which should affect the validity of this plea? Mr. Eichholz?
No, Your Honor.
Mr. Owens?
No, Your Honor.
In that event, I find that Rodney Stouty is acting knowingly and voluntarily in entering this plea, that he fully understands his rights and the consequences of this plea, and that a factual basis exists for the plea. Court accepts Mr. Stouty's plea of guilty to the charge of murder in the second degree in violation of Iowa Code Section 707.1, 707.3 of the Iowa Code. I need to inform you of some rights, Mr. Stouty, because I understand you want to be sentenced today, and that's going to affect these rights that I'm about to tell you about, okay?
Okay.
It's my duty to inform you that if you were to try and challenge your guilty plea that you just entered here, you would have to file a document we call a motion in arrest of judgment. And that document must be filed no later than 45 days from today's date, or at least 5 days before you are to be sentenced, whichever comes first. Do you understand that?
Yes.
And that if you do not file that motion in arrest of judgment within those time frames, you are giving up the right to file that motion and appeal your guilty plea. Do you understand that?
Yes.
Okay. Now, the attorneys tell me that you wish to give up any time to delay sentencing in this matter and to proceed to being sentenced today on this charge. Is that correct?
Yes.
Okay. So there are a few more things that will affect. So we just talked about that motion in arrest of judgment.
Yes.
If you get sentenced today, you're giving up the right to file that, and you said you understood that. You also have the right to delay your sentencing hearing for at least 15 days from today's date. Are you giving up that right to have the delay in sentencing?
Yes.
All right. Now, Mr. Stouty, we've seen each other once or twice before in court, correct, sir?
Correct.
But other than that, you and I do not know each other, do we?
No.
No, we don't. So really, all I know about you is what I have read in the court file, what I know from you from the few interactions that we've had, and from what the attorneys have told me. So normally, to learn a little bit more about you before the court decides on what sentence is appropriate, I would order what's called a pre-sentence investigation report, where you would meet with a person from the Department of Corrections. They would ask you questions about your upbringing, your education, your work history, if you've ever been in trouble before with the law, and other questions that they would then put into a report to provide the parties and the court more information about who you are, and that would help me decide what sentence is most appropriate. Now, if you want to be sentenced today, obviously there's not going to be a chance for anybody to ask you those questions or prepare that report. Do you understand that?
Yes.
Okay. And do you wish to give up that right to have a pre-sentence investigation report prepared and to be sentenced today?
Yes.
Does either party know of any legal cause why we cannot proceed with sentencing today? Mr. Eichholz?
No, Your Honor.
Mr. Owens?
No, Your Honor.
All right. Court finds that Mr. Stouty is knowingly and voluntarily waiving his right to file a motion in arrest of judgment, waive his right to time before sentencing, and for the court to consider a pre-sentence investigation prior to sentencing. And the court hereby accepts Mr. Stouty's request for immediate sentencing.
That didn't work right. That didn't work right. You did fine. I hope so.
Right, it's an extraordinary situation there. He's waiving the pre-sentencing report. They're going to go right into sentencing. What we're going to do is we're going to take a break here. When we come back, we'll have more of this newborn left to die sentencing and hear what his sentence will be.
Back now to Iowa for the sentencing of a grandfather of an infant as well as the mother of the infant. They both killed the infant's son, threw his body into a bag into a ditch. Megan Stouty pleaded guilty to second-degree murder in the death of her infant son in July, and her father today entered a plea to the same charge.
Yes, he did, and Stouty told police that she gave birth to a baby boy in February and admitted to putting the child in a trash bag while he was still alive and then tossing into a ditch with the help of her father, the baby's grandfather. She faces up to 50 years in prison, as does he.
And before the sentencing began, her father, as we just mentioned, didn't take a plea deal and requested to be sentenced right away. The court is advising him of his rights to go proceed with that sentencing. And now we're going to go back in where the prosecution is about to recommend his sentence.
And why don't you go ahead and give your statement and sentencing recommendation, Mr. Eccles.
Thank you, Your Honor. Your Honor, this offense is purely senseless. In 29 years of practice of law, I've dealt with many, many things, as most of the other counsel in this room have. But I can't think of any case that's been more senseless than this one. The level of harm that this individual has caused to his community is outrageous. It doesn't just go to the baby, it goes to the first responders, the police officers that went there. It goes down to the other investigators who helped figure out what happened in this case, all the way down to the women and co-workers of the co-defendant in this case who tried to intervene and help do the right thing in this case. All these people have to live with what Mr. Stouty did. And that is why it's just completely senseless and why we shouldn't even be here today. But of course we are. State recommends the minimum sentence of 50 years in prison, that he serve the mandatory 70% or 35 years, that he provide a DNA specimen pursuant to Iowa Code Section 81.2. There is no fine under 902.9. Also that he pay the $150,000 death award under 910.3 capital B, and that he be jointly and severally liable with his co-defendant in this case. Also, there will be no bond on appeal due to this being a forcible felony. Even if that wasn't mandatory, Your Honor, that would be appropriate in this case, and we would ask the court to follow the code in this case. Thank you.
Thank you, Mr. Eccles. Mr. Owens, anything on behalf of your client?
Yes, Your Honor. Your Honor, on behalf of Mr. Stouty, we have nothing to offer as far as evidence is concerned, Your Honor. There's nothing we can tell the court that's not already in one of his psychiatric reports from Oakdale, from other doctors. And as Mr. Eichholz has said, this is a mandatory sentence. We've agreed to that sentence, and Mr. Stouty would like to proceed with the sentencing today.
Thank you, Mr. Owens. Mr. Stouty? As I said before, I only have limited information about you, so I want to make sure that you have an opportunity to tell me anything you think I need to know before we actually pronounce a sentence.
I don't feel like to.
You don't want to, sir?
No.
Okay. And you have that right as well. Mr. Eccles, any victim impact statement on behalf of the state?
I do, Your Honor. I have a statement on behalf of Zach Wilson, the father of the baby in this case, if I may read it to the court.
You may.
Mr. Wilson is unable to be with us today due to illness, and he's asked me to read this. I hope you get what you deserve. I am totally and emotionally broken for what you did to my son, who was only a baby. Who does that to an innocent child who has not yet seen the world with his own eyes and see who his father is? It's disgusting how you treated him. He never deserved that or any other child. Do you not have a heart to love or care about someone or just yourself? Because that's not how you treat a child. Megan, you deserve to be punished, and I hope that you get it, what you deserve. Now, Rodney, I don't understand why you would let this happen or join on this. You're just as guilty as your daughter. You guys have emotionally abused me and my wife, my family, and I can't even handle funerals when my loved ones pass away. I can't even focus on my past jobs. I could hardly ever talk to my adopted parents about how I feel about this and how I should cope. I can hardly even sleep without thinking about why would someone do something that cruel. Anyway, I hope you guys get what you deserve.
Thank you, Mr. Draper. Anything further on behalf of the state?
No, Your Honor, thank you.
Counsel, does either party know of any legal reason why judgment and sentence should not now be pronounced? Mr. Eichholz?
No, Your Honor.
Mr. Owens?
No, Your Honor.
Mr. Stouty, under Iowa law, depending upon what the offense is, sometimes the judge has more of a decision to make about what a sentence should be. The offense of murder in the second degree is not one of those offenses in Iowa. The law very clearly sets the penalties that the court has to impose. Normally, I would discuss things such as your age, prior criminal history or lack of criminal history, your employment and family circumstances, certainly the plea agreement, and the nature of the offense as things that I consider if there was a range of a sentence that I could impose. Because this is a fixed sentence, I'm going to actually take this opportunity to speak to you in the hopes that during your term of incarceration, if you don't already understand, maybe you will understand why you're being sentenced to 50 years, a term not to exceed 50 years, with a mandatory minimum of 70% of that, without any chance for probation or parole. As human beings, we hopefully carry a sense of duty to our fellow human beings, to treat them how we would want to be treated. I see a lot of law enforcement here in the courtroom today that had some involvement in this case. Law enforcement does the job that they do because, for the most part, they feel a sense of duty to serve their fellow human beings. And that comes at a great cost sometimes. But there are certain situations, certain roles in life where you have to accept.
All right, there you see Rodney Staude, 68 years old. He's going to be sentenced to 50 years in prison because it's set, and it's also set by the statute, and he agreed to it. He'll serve at least 30. He'll be over 100. He'll probably die, absolutely will die in jail. Let's bring in our guest, still with us, criminal defense attorney Josh Schiffer. And Josh, this is one of those ones that make you question the system, right? Even if you're in the system, makes you question the system. The facts as he recited them clearly suggest first-degree murder, But the court and everyone agreed that second-degree murder was the right resolution as far as a plea deal. Some people might have a problem with that. What say you?
Well, you know, a lot of what the court didn't get into was the background of his competency. And this gentleman, for people that aren't aware, suffers from some disabilities. And we don't have all of the details to that, but had been previously found not competent. And then the process returned him to a penal medical facility until he regained competence. And that is the only juncture at which point the court can enter a plea. And being that this is a case where any sentence basically includes the rest of his life, the system kind of snips off the edges there. And it says, hey, we're going to get this done because we're going to get it done. And we're not going to fight about the details because everybody deserves closure of this case.
Yeah, this case is a hard case at best, but
I'm glad someone spoke for the baby.
yes,
I didn't realize
we
the father
talked
was
about
around.
that. Who was going to speak for the victim? And understandably, he said, yeah, it's disgusting what was done to his baby. All right, thank you so much, Josh Schiffer, for being with us today. Up next, we're going to have more of the newborn left to die sentencing hearing. We'll be right back.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Martell ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
Welcome back to Court TV Live. Sentencing is underway in Iowa for Megan Stouty. She's the mother who confessed to killing her infant son and then throwing his body into a ditch.
But first, the judge is sentencing her father, who just today pleaded guilty to second-degree murder and helping her. Let's go back inside the courtroom now. The judge is about to hand down the sentence for her father.
But there are certain situations, certain roles in life where you have to accept cost to yourself in order to do the right thing. And as high a calling as law enforcement, firefighter, or military may be, there is no role in life with a higher duty than that of a parent. And that extends down the line to the rest of your family, to not only your child, but to your grandchildren. Mr. Stouty, I don't know what issues you have faced in your life up to this point in your over 6 decades. I am confident that any person I meet, while they may not have been the same issues that I or someone else have had to face, everyone has had issues in their life. But there are certain things in this life, regardless of the issues that you've had to deal with, where you have to rise above those. And you have to do the right thing. And you had a choice in this situation when you had a grandchild born. I know it may not have been the best of circumstance. May not have been what you asked for or what Megan asked for. But that life had as much right to life as you or Megan. And that life was helpless and depended upon you and Megan. and the steps you took denied that life an opportunity to love, to grow, to live. And that's why the penalty that the law imposes is what it is. So having considered in light of what the law will impose here, that sentence will protect the community from further offenses by you, but also afford you the maximum opportunity rehabilitation, I hereby adjudge you guilty of the offense of murder in the second degree in violation of Iowa Code Section 707.3. And the court, acting pursuant to the provisions of Iowa Code Section 902.9, I hereby commit you to the custody of the Director of the Iowa Department of Corrections for an indeterminate term not to exceed 50 years. The Iowa Medical and Classification Center at Oakdale, Iowa is designated as the reception area. There is no maximum or minimum fine imposed pursuant to this sentence. You are ordered to give a sample of your DNA to be kept on file with the state of Iowa for the purposes of profiling. Additionally, you will be ordered to pay a $150,000 civil penalty because of the loss of life associated with this charge. That civil penalty, it will be jointly and severally liable with any other co-defendants. Mr. Stouty, I'm now required to inform you that this is a final judgment of the court. Therefore, I need to inform you of your appeal rights. As we discussed briefly before, because you voluntarily entered a guilty plea, you have no right to an appeal of that guilty plea, unless you are to allege good cause or a defect in the plea proceeding or an improper denial of a motion and arrest of judgment. In that case, you would have 30 days to file a written application for permission to appeal and an application to authorize, at least initially, a transcript to be prepared of these proceedings at state expense. Ultimately, though, it would be up to any appeals court to determine whether your application would be granted or denied, or under what conditions, if any, it would proceed. You are further advised that if you decide to appeal the judgment of sentence I just pronounced in this case, a written notice of appeal must be filed again within 30 days of today's date. Filing of a notice of appeal is what we call jurisdictional. That means that if you don't file it within that 30 days, you give up that right. If you are unable to afford the costs of an appeal, again, at least initially, an attorney and a transcript could be furnished to you at state expense. A plea of guilty with an agreed upon sentence, like we had in this case, would be subject to the application for permission to appeal requirement I just mentioned about the guilty plea. You are currently represented by attorneys, so if you decided to appeal, your attorneys must file the notice of appeal for you. That means you yourself can't file it, and if you did, I would have to reject it. Both of your attorneys are very experienced and are qualified to answer any other questions you may have about your appeal rights. Pursuant to Iowa Code Section 811.1, subsection 2, subsection C, there is no bond on appeal for this particular offense.
All right, no surprise, after the defendant agreed to the max sentence and the state recommended that, that is what the judge did. 50 years and that's the possible max. He could serve 35 under the current laws in that state.
No, he will serve a minimum of 35.
Right, I'm sorry, yes. But he could be released after 35
yes.
if he's still alive.
If he's still alive, because he's 68 now. That would make him over 100 once that 35 years is up. And, you know, again, as Josh said, this is the way the system decided to resolve this case, rather than go through a trial. And as he said, save us from all the things that we would have had to have listened to regarding this poor child.
And I just have to mention, he was not competent to stand trial. They restored his competency, but it could always be that when they then go to have the trial, he's incompetent again. So it prevents that from recurring.
Yeah, I think at the end of the day, a decent result. All right, we'll take a break here. Coming up, the baby's mother now. Megan Stouty learns her fate in the newborn left to die sentencing case. We'll hear what she has to say to the court. She speaks as well. You're not going to believe what she says. Stay tuned here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. We are bringing you the sentencing for defendant Megan Stouty in the newborn left to die case in Iowa. Stouty pleaded guilty to second-degree murder back in July.
Investigators say that she put her newborn in a box and ignored his cries for 2 days, gave him no love at all from the moment he was born, and then put him in a plastic bag while he was still alive, and then left him on the side of a snowy road with the help of her father, Rodney Staude. And in a surprise move today, we just showed you before Megan's sentencing, her father pleaded guilty to the lesser charge of second-degree murder as well, and he was sentenced to 35 to 50 years in prison.
Now, we want to get you back inside the courtroom where the sentencing hearing for Megan is just beginning.
This is the Iowa District Court for Warren County. We're here in the matter of State of Iowa plaintiff versus Megan Catherine Stouty, defendant. Docket number is FECR 034221. On March 24th, 2023, the State of Iowa filed a trial information in this matter, charging Megan Stouty with murder in the first degree, a Class A felony. Subsequently, parties entered into a plea agreement, and on July 3rd, 2024, Ms. Stouty entered a guilty plea to the lesser included offense of murder in the second degree in violation of Iowa Code Section 707.3. At that time, the court did delay sentencing, but did order the preparation of a pre-sentence investigation report. Eventually, by agreement of the parties, sentencing for Ms. Stouty was set for today's date and time. On August 21st, 2024, a pre-sentence investigation report was filed with the court. The court has had an opportunity to review the pre-sentence investigation report prior to today's sentencing hearing. Mr. Echols, did you receive a copy of that report, and do you have any additions, deletions, or corrections, or any objection to the court using the PSI in sentencing?
Thank you, Your Honor. Your Honor, I have reviewed a copy of the pre-sentence investigation, so I have no additions, corrections, or deletions to that report.
Thank you, Mr. Echols. Ms. Eimerman, will you be speaking on behalf of Ms. Stouty?
Yes, Your Honor.
All right. Did you receive a copy of the pre-sentence investigation report? And I guess particularly because it's been quite some time since it's been entered, do you have any additions, deletions, or corrections?
No, Your Honor. We've received it. We provided a copy with our client, reviewed it again today before the hearing, have no additions, corrections, or deletions.
All right. And do you have any objection to the court relying upon the pre-sentence investigation for the purposes of sentencing?
No, sir.
Mr. Echols, any evidence or testimony to be presented on behalf of the state?
I do have a victim impact statement from the father in this case, and just my own statements.
All right. Mr. Echols, why don't you go ahead and give your arguments and sentencing recommendation?
Thank you, Your Honor. Your Honor, as I stated earlier during Mr. Stouty's sentencing, I've been practicing law for about 29 years, 25 of which I've spent as a prosecutor. Over that time, I've seen a son kill a father. I've seen a man kill a woman for the words that she used toward him. I've seen a boyfriend kill his girlfriend. I've had unsolved murders. And now we get to this case, and we have a baby that was killed by the mother and the grandfather. And I think in talking with the first responders, police officers who went to the scene and found this young child, the baby, discarded in a ditch like trash, sums this case up. Because that's what Miss Stouty and her father did. They put the baby in a trash bag, drove out of town, and threw it in a ditch. And we often say that sometimes communities say to themselves, we could have done more. Why didn't we do more? But this is the opposite of that, because in this case, the people in her orbit, the people around her, tried everything that they could to make a difference in her life. They knew she was pregnant, even though she denied it. They tried to intervene on her behalf. They tried to take her to places so that she could learn what services were available. They did their best. They said, we will support you if you need to move out of your family's home to support this baby. And they did all these things to try to help Megan. And she didn't take their help. So when we say the community could have done more, the community couldn't have done more. And the saddest part about this is that Megan knew the options that were available to her. She knew about the Safe Havens law, yet she didn't take advantage of it for whatever reason. And that is probably the most frustrating thing about this case, is that she knew better and she didn't. And that's what makes this so senseless. In this case, obviously, the court is going to impose a 50-year mandatory sentence. And she's going to have to do 70% of that. And that is by code, and it's obvious. But it doesn't make up for what she did in this case. She will need to provide a DNA specimen. There is no fine under 902.9, but she will be responsible for a $150,000 death award under 910.3b, and we've asked that she be jointly and severally liable with her father, Rodney Staude, in this case. There is no bond on appeal because of this being a forcible felony. Your Honor, we ask that you follow the code in this case and impose that sentence. Thank you.
Thank you, Mr. Edwards. Ms. Eimerman, on behalf of your client.
Thank you, Your Honor. May it please the court. Your Honor, nothing about what happened in a vacuum. And I know that whatever we say today on behalf of our client will likely be construed by many as an excuse. But the reality is that this family, like most families, was complex. It was a complicated little family. And Megan's mother, by all appearances, seemed to have been the glue that held this family together for as long as it did. And as the court knows from having read the PSI, that when Megan's mom died in 2018, Megan was lost. Her mother, she said, was her everything. And so when she died in 2018, this little family that had just kind of managed to exist on the edge of society was just kind of lost. And so when Megan found herself pregnant, her mom wasn't there. And actually, the two men in her life who bore some responsibility in this situation, they weren't there either. Court just heard from her dad, who wasn't there to step up and help her. And the father of this baby that died abandoned her. He blocked her on social media, on Instagram. He changed his number so that she couldn't contact him. Like I said, Judge, nothing about what I've just said is intended to be an excuse. But it's true, and it is an inextricable part of what happened. And Megan has to live with it too. This is a mandatory sentence, Your Honor. We have a plea agreement. We are asking the court to follow that plea agreement. And Mr. Eichholz is right. It doesn't make up for what she did. Nothing will make up for what she did. But she's here today. She accepts responsibility for what she did. And she respects that this is the sentence that the court is going to impose for what she did. Thank you.
Thank you, Ms. Sandler.
I have to tell you, Michael, we know it's a mandatory sentence of 50 years. She has to serve at least 35 of those. It's very hard for me to hear defense attorney. You have to work with what you have, but to say it didn't happen in a vacuum, Megan has to live with it too. When you also hear she even knew about the safe haven law that you mentioned, that you can drop off a child without being prosecuted.
That's what blew my mind.
Yeah.
Because we were talking about that maybe they didn't even know that existed, and that's why they took this route. But she knew it existed.
Yeah,
and again, it just boggles the mind that they would allow her to plead to a second-degree case, but sometimes you resolve these cases and you just gotta move on.